victims have asked a U.S. court to order Tether to release frozen USDT linked to Iran. This request is part of a legal filing that seeks judicial intervention to unblock assets tied to sanctioned activity. The case highlights a growing legal and regulatory debate about the power of stablecoin issuers to freeze user funds on-chain. Tether, as the issuer of USDT, has the technical ability to blacklist wallet addresses, effectively locking funds in place. This centralized control is now being tested in court, as petitioners argue they have a legal right to assets that are currently inaccessible. The request is not framed as a voluntary action by Tether, but as a court-directed order, which could set a precedent for how courts handle frozen stablecoin assets in the future. What makes this case particularly notable is the intersection of legal accountability, sanctions enforcement, and stablecoin mechanics. When Tether freezes USDT, the tokens remain on the blockchain but cannot be moved. This creates a situation where assets are technically visible but legally unusable. The victims are seeking a court order to release these funds, which could force Tether to act in a way that aligns with judicial directives rather than just regulatory requests. The legal request also raises broader questions about the responsibilities of stablecoin issuers. Unlike decentralized protocols, Tether is a centralized entity with direct control over token movements. This means it can respond to law enforcement requests by freezing wallets, but it also means it could be held legally accountable for decisions that affect users' access to funds. The fact that these tokens are most people arrive after the move is obvious and the easy upside is gone. We focus on serious crypto education and high-quality signals before the crowd rushes in, so you can understand the setup earlier and move sooner. If you want that edge, visit the link below now. Linked to Iran adds another layer of complexity. U.S. sanctions against Iran mean that any assets connected to Iranian entities face heightened scrutiny. Tether has previously frozen tokens at the request of law enforcement, but this case could mark a shift toward court-ordered actions rather than voluntary compliance. The identities of the victims and the nature of their claims have not been fully disclosed in public filings, but the petitioners are clearly asserting their legal right to the frozen assets. This raises the question of who, exactly, has standing in such cases and how courts will interpret ownership of frozen stablecoins. The legal request also brings attention to the broader issue of asset limbo in the crypto space. When tokens are frozen, they are not lost, but they are effectively unusable until a decision is made about their disposition. This creates a legal gray area, especially when the frozen assets are tied to sanctioned entities or activities. If the court sides with the victims, it could force Tether to release the tokens, potentially triggering a cascade of similar legal actions. On the other hand, if Tether resists or the court rules in its favor, it could reinforce the idea that stablecoin issuers have broad discretion to control token movements. The next signal to watch is whether the court will accept the victim's request and how Tether will respond. If the court orders Tether to release the funds, it could signal a shift in how legal systems interact with stablecoin mechanics. If Tether resists, it could lead to a legal showdown that tests the boundaries of stablecoin control and user rights. The case also highlights the unique position of stablecoin issuers like Tether, who operate at the intersection of blockchain technology and traditional legal systems. Because Tether can freeze and unfreeze tokens at will, it holds a level of control over user assets that is not typically found in traditional financial systems. This control is not inherently problematic, but it does raise questions about transparency, accountability, and user rights. The petitioners are arguing that Tether's actions have legal consequences and that a court should be able to direct the release of frozen funds in specific cases. This could lead to a broader conversation about the legal status of stablecoins and the responsibilities of their issuers. The stakes are high not just for the victims in this case, but most people arrive after the move is obvious and the easy upside is gone. We focus on serious crypto education and high-quality signals before the crowd rushes in, so you can understand the setup earlier and move sooner. If you want that edge, visit the link below now. For the entire crypto ecosystem, if courts begin to assert more authority over frozen stablecoin assets, it could change how stablecoin issuers operate and how users interact with these systems. It could also lead to increased legal scrutiny of stablecoin mechanics and the potential for more court-ordered interventions in the future. The outcome of this case could have ripple effects beyond Tether and USDT, influencing how other stablecoins and blockchain platforms are treated in legal contexts. If the court grants the request, it may establish a new framework for handling frozen digital assets. If not, It may reinforce the idea that stablecoin issuers have broad discretion in managing user funds. Either way, the case is an important test of how traditional legal systems are adapting to the unique challenges posed by blockchain-based assets.